Today. I'm speaking today in opposition to SB 302 because it rolls back existing groundwater protections and jeopardizes DNR's ability to adequately protect the resource. We should be here talking today about how we move forward with groundwater protections, not backwards. In 2004, the Groundwater Protection Act, Act 310, addressed some major concerns about groundwater protection in Wisconsin based on recommendations that were developed after careful analysis and debate among a group of diverse stakeholders. But at the time, it was a positive step forward, to be sure, but it was acknowledged by everyone who was part of that compromise that it was just the first step in achieving sustainable groundwater management. SB 302 sets Act 310 as the ceiling for groundwater protection, rather when in fact it should be the floor. Clean Wisconsin was a supporter of Act 310. However, it did leave many of Wisconsin's groundwater problems unaddressed. In fact, the 2007 Groundwater Advisory Council's report to the legislature unanimously recommended that as a next step, the state develop water management legislation and a comprehensive state water management policy for the long-term management of water resources. That unanimous recommendation of the Groundwater Advisory Council, which included representatives from agriculture, municipalities, environmentalists, well drillers, regulators, and industrial interests, should not be taken lightly. As you can imagine, it wasn't a group that agreed on a whole lot, but they unanimously made that recommendation to take a next step forward. And we have not yet done that in Wisconsin. And I've outlined some of the key issues that they would like to address in future legislation unanimously. And I think the last one is the important one here, seek to ensure adequate water supplies for future generations. I'm just not seeing how SB 302 achieves that goal. And even the cover letter of the 2007 report refers to Act 310 as a first step in integrated water management, but acknowledges, quote, that further work remains to be done to build upon the successes of Act 310. Now it's nearly 10 years since Act 310, and Wisconsin's problems with groundwater are only getting worse. Lakes and rivers are drying up, private wells are being impacted, and people are getting really concerned about their access to water. People are so concerned, in fact, that they're taking their case to the courts and in contested cases since the legislature has failed to take the necessary steps to protect their access to water. One of the weaknesses of the 2004 bill was that it didn't adequately protect surface water. It's this weakness that led residents around Lake Beulah to challenge the DNR's issuance of a high-capacity well permit to the village of East Troy, which, as we talked about here, ended in a unanimous court decision that said DNR has the duty and obligation to consider surface waters when evaluating high-capacity well permits. This unanimous decision recognized the constitutional right in Wisconsin that our water resources belong to everyone, and that giving water use rights to one group over another is considered unconstitutional in Wisconsin. In 10 years, this has been the only step forward for groundwater protection, and SB 302 only seeks to take us back. This bill will leave people with few options to prevent impacts to their own property, especially when combined with the budget language regarding high-capacity wells that limits people's ability to contest a permit based on cumulative impacts. That was language in the budget. There are growing concerns since the 2004 Act was passed. There are 40% more high-capacity well applications in Wisconsin than just 2 years ago, and the trend doesn't seem to be slowing. You can imagine the incredible strain that's putting on DNR and its resources. By now, the stories of lakes and rivers drying up in central Wisconsin are well known, but problems exist in other areas. Waukesha is having problems with drinking water access. Madison is having drawdown issues. Green Bay had at one point groundwater issues. Those have all occurred in the last 10 years. The Central Sands area of Wisconsin has certainly become the poster child for groundwater quantity issues. 1/3 of the 288 billion gallons of groundwater withdrawn annually in Wisconsin comes from the Central Sands, which is only 5% of the state's area. The Little Plover River has dried up, and some residents are watching their once lakefront properties dry up on other lakes in central Wisconsin. The frac sand mining boom in western Wisconsin is raising new concerns about impacts of high-capacity wells. In one known instance, a frac sand mine operation ended up digging in a new well for a farmer after his well ran dry because of their new well. Groundwater is a finite resource, and it must be protected against overuse. In addition to moving us backward, SB 302 puts a strain on resources at DNR that are already stretched thin. The 65-day presumptive approval will be difficult to meet with increased volume permits and required review under the Lake Beulah decision that this bill is not changing. Although the language of the bill is unclear, I noticed unclarity, maybe that got resolved here today, unclarity about the circumstances under which DNR could deny a permit or when they deem it complete. There's little doubt that in our minds that the bill will at least lead to more court challenges, if not more denials, which serves to strain the DNR resources even more. It just becomes this catch-22 where they can't get to the permits because they're dealing with more and more challenges, and it's, I know, straining their resources. SB 302 also takes away the flexibility that DNR has to work with an applicant to apply conditions to a permit that will help balance property rights for all users, lakefront homeowners, farmers, and people with private drinking wells. Common sense permit conditions like monitoring a well's impact and preventing significant adverse impacts would not be allowed under this bill. The impact of SB 302 on private property rights is unclear, but the bill does create permanent water use permits that run with the land. This is at the very least a new approach to water management in Wisconsin, one that basically assigns water resources to existing well owners at the expense of neighbors or new wells. Under that provision, new industry coming in may not have the same access to groundwater resources that others enjoy. It also means that as more problems are discovered with groundwater quantity, those permits can never really be altered. A private right to that groundwater is basically guaranteed. And while DNR under Chapter 3003 has authority to pursue relief regarding possible infringements of public rights to navigable waters, that is really an authority that obviously DNR has indicated it's never used with regards to high-capacity wells. And for Clean Wisconsin, it's really an authority that exists on paper. The administrative burden to doing a 3003 action is, it's just never going to happen. I have absolutely zero faith that would ever happen. There are problems that are cropping up with high-capacity wells, and 3003 still has not been used. Not to mention that 3003 only covers navigable waters, and it does leave protections for isolated wetlands and private drinking wells unaddressed. So if those issues come up, DNR can't exercise a 3003 authority. For these reasons, we respectfully ask that you oppose SB 302, and I'd be happy to take any questions.